Welcome. Welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. I hope this series is for you. I know it is. If you believe in our Constitution, if you believe in justice. Well, here, I'm designing this series to give my students a little something extra about the law. For informational purposes, I teach at Mississippi College School of Law, and I've been teaching there and teaching at business schools and other schools for about 30 years. All views, all interpretations here, though, are my own and not to be ascribed to my school or students. Now, this semester, I'm trying to, again, encourage my students to take a soak in the law and not just a quick shower. So I wanted to give them a little something extra, although I am teaching in person. Now, with each of these short clips that I'm doing some video shorts just to talk with you for under 10 minutes. I'm trying about some term of art, some principle in constitutional law. And today we're going to talk about levels of judicial scrutiny. Now, we said earlier that there are three branches of federal government, three co-equal branches: the courts, the federal courts, the executive, and Congress. In addition, some powers are left for the states, and there are individual rights. Now, the U.S. Supreme Court, it has articulated for itself the power of judicial review. Judicial review. That means the court says, you go ahead and act. Then after you act, we'll tell you if you got it right under the Constitution. And I'm simplifying that. But with this judicial review, there are different levels of judicial scrutiny. How closely the court scrutinizes the actions of others of the other branches of government. So I told you in the last clip that I'm going to tell you, or try to tell you, a little story about myself, maybe every now and then, that may help you to remember the principle. So the principle we're talking about here is judicial review, the levels of judicial scrutiny. Now, when I was growing up, my mother gave me a certain degree of freedom to make certain choices for myself. She would guide me. She would try to encourage me to reach the right result. I was sort of a quiet girl, sort of a bookworm. So I pretty much made good decisions. Well, sometimes I made good decisions. But there was this one instance where I was selecting this dress to wear to a wedding. And I thought someone that was really special to me was going to be there. I was a teenager then. I went shopping. I picked out this hot pink dress. It was a mini dress. I did wear mini skirts in my day, not micro minis, but it was a mini. And the store didn't have my size, so the size I got was a little snug. When I got home and tried it on and told Mama I was going to the wedding and this is what I would wear, isn't it precious? Mama was really kind of quiet and she said, "Are you sure? Are you sure that's what you plan to wear?" I said, "Yes." She said, "Are you sure you want to be comfortable in it?" I said, "Yes." "Are you sure it's appropriate?" I said, "It's cute." She asked me a few more questions and then she said, well, you go ahead. You do what you think is best, what you think about what I've told you. So I wore the dress to the wedding. And when I got back, Mama asked me, she said, well, do you plan to wear that dress again? And I said, I do not. I do not. She usually didn't scrutinize my choices that carefully in dress apparel. She did that time, but she let me learn, and I learned the hard way. Let me just tell you, the dress was hot pink. It was hot pink, and I was a hot mess. So the term of art, well, look, I think it all connects up. Anyway, the term for the day is judicial review, and more specifically, the levels of judicial scrutiny. You see, the general rule is that when government does something, the court is not going to intervene. The general rule is that all government has to show is that its actions meet a very low level of rational basis. All government has to show that it has a legitimate governmental interest, and what it chooses to do is rationally related to that interest. But in a case with one of the most celebrated footnotes in constitutional history, Carolyn Products, Justice Stone said, hey, wait a minute. Sometimes we need to scrutinize government more. When government intrudes on individual rights and liberties, we need to scrutinize it more. And when government is making decisions directed at racial and religious minorities, we need to scrutinize government more and question what government is doing. So as a result, the court has, we do still have rational basis review, but sometimes the court uses heightened levels of review. And one is called strict scrutiny, the most exacting level of review. Government must have a compelling governmental interest in taking that action, and its action must be narrowly tailored to that interest. And then, of course, this is the law. We can't just have rational basis at the bottom and strict scrutiny exact. You know there's one in the middle. The one in the middle is called mid-level or intermediate review. Look, again, I'm just getting warmed up to talk about these levels of judicial scrutiny. And I keep thinking back to that story when my mother was scrutinizing my decisions more. So sometimes decisions or actions by government are scrutinized on the low level, and sometimes they're scrutinized more because the court says more is at stake, like individual liberties and also actions directed at certain groups. Now, I know you want to learn some more. If you do want to learn some more, and I believe you do, then look in the text box below and you will see a link to the longer video that talks more about scrutinizing government. Isn't learning wonderful? Learning is on the pathway to freedom and freedom to justice, or at least a taste of justice. Subscribe and sign up for notifications. You don't want to miss a thing. You certainly don't want to miss the next story I'm going to tell you about my childhood. Okay, you take care and see you in maybe a week. Okay, bye.